What is Schedule F? You've probably heard about it. You've heard a lot about it. You've seen headlines about it. It actually started back in October of 2020 when President Trump issued an executive order in his first term to create Schedule F. What is Schedule F? What's the basis for it? Why did he issue it? What are the implications for you as a federal employee? And what employees will be in and what employees will be out? The executive order issued by President Trump the first day of his second term is restoring accountability to policy influencing positions within the federal workforce. And technically, it's not Schedule F, it's now called policy/career. For this video, I'm going to use the term Schedule F since that's what everybody's still calling it, and that's essentially what it is. The new executive order doesn't change much at all over the one issued in 2020. That one never got implemented because it was issued in the very last portion of the president's term. Obviously, he corrected that problem this time. It was issued on the very first day, so he's quite serious about enforcing it and getting it rolling in the federal workforce. Why is it issued? According to the executive order, he says there have been numerous cases of federal employees resisting and undermining the policies and directives of their executive leadership. Obviously, he's referring back to his first term when that was the impression of the president and a number of the people who worked for him, and they want to correct that. He says that good administration necessitates restoring accountability among the federal career workforce. And that's what this is intended to do. And that's why he said he's doing it. And according to the executive order, it applies to positions of a policy-making character. And if you look at your position description, if your position describes policy, making policy, recommending policy, creating policy, you might find yourself in Schedule F. Schedule F employees would not be subject to having the civil service protection that you have as a career employee. In other words, as a political appointee instead of a career employee, if you're fired, if the administration decides to fire you, whether that's somebody supervising your agency or the president himself, you don't have the same career employee protections. You can be fired and there are no appeal rights. That is what he intends to do because it would provide more incentive to work to administer what the administration wants to accomplish. According to the executive order, it's designed to maintain professionalism and accountability within the civil service. And he said that accountability is lacking today. So that's the purpose behind Schedule F. What's the legal basis for it? There's a provision in the Civil Service Reform Act of 1978 that reads, the provision exempts from civil service protection employees whose position has been determined to be of a confidential, policy determining, policy making, or policy advocating character. Now, this provision hasn't been given a lot of attention since it was passed in 1978. It didn't really get attention until people working for the administration in reading it over and identifying the problem they had of the career employees not performing the work they thought they should be doing, and are using that as a way to create a more effective workforce, their view, by removing these civil service protections. As many people know, firing a federal employee by the time the appeals are done can take years. And they want to get away from having that. So by now, if you put into Schedule F, assuming this gets through, then you won't have years to file appeals. You won't be able to file appeals. So the issue is done. What happened in the first term that caused this? The executive order doesn't say this, but I think probably this is the kind of actions that the administration says were occurring that they wanted to correct. And this was in an article by a man named James Shirk, who had a lot of influence in the civil service arena in his first term, and will again in the second term have something similar to that in his portfolio of what he's going to be doing for the administration. He said he ran into these kind of problems, and I'm listing them here, not in all agencies, mainly in a few agencies, but enough to create issues because some of those agencies are the ones where their policies would have the most direct effect. These included withholding information from administration officials, refusing to implement policies, intentionally delaying or slow walking priorities. In other words, it was taking a long time. I'll get around to it when I can, kind of thing. Deliberately underperforming so the work doesn't get done and the administration doesn't get its objectives accomplished, leaking information to Congress and to the media to try and stir up dissent or criticism to try and prevent policies from being introduced or enforced. And finally, outright insubordination. Obviously, if you're not able to file any appeal, that's a pretty effective way to get people to do what you want to do, and that's the purpose of this Schedule F. Some employees are not covered. For example, intelligence community employees typically will not be covered, don't have career civil service protections. Some agencies, intelligence agencies, have issued some for their employees, not all. It depends on the agency and where the employee works. Now, if an administration wants to have an intelligence community employee not able to do his job, they can just withhold the social security clearance. And we saw this week that's already happened to a number of people who were involved in something involving the Hunter Biden case. So their security clearance has been removed. That makes them less effective, and it may mean that they're out of a job. That depends probably on the individual. Schedule F doesn't affect senior executive service. SES people, some of them are already political appointees, they're career people also. So it depends on what kind of appointment the person has. There are ways that an administration can strongly encourage SES employees to resign. For example, SES was passed in the CSRA to make it a more mobile workforce. So SES employees can be moved by an agency if they determine that we need you in a different location. So, for example, if you have a senior executive working in Washington, perhaps he's been there his whole career, and most of them are, or many of them certainly are in the DC area, but we now need you in a remote area where you're probably not going to like it very much. But you can go to accept this assignment and you'll continue to be an employee, or you can resign, or we can fire you. Now, that usually works very effectively. Political loyalty isn't required by this. The administration has put into the executive order a statement that said applicants or employees in these Schedule F jobs are not required to personally or politically support the current president, or they don't have to like his policies, but they are required to faithfully implement administration policies to the best of their ability, consistent with their constitutional oath and the vesting of executive authority solely in the president. So, what he's saying is you don't have to like the policies, but if you want to keep your job, then you're going to have to work with us to administer them. In theory, the civil service is a nonpartisan federal workforce. They work to help whoever the president is that's in power. The civil service was created back in 1883. Now, of course, unions didn't exist. Civil service positions or protections for civil servants didn't exist. Most of those came into effect in the 1940s or later. President Kennedy issued an executive order in 1962, creating the ability of federal employees to represent employees. That was incorporated into law in 1978. The unions are strongly opposed to Schedule F. A lawsuit's already been filed about it. And one of the unions came out with a statement that says his order is a blatant attempt to corrupt the federal government by eliminating employees' due process rights so they can be fired for political reasons. Is the federal government a non-political workforce? You've got the Hatch Act preventing actions by federal employees of a political nature, and that the special counsel will investigate. And some employees have been fired, disciplined, etc., for engaging in political activity. That doesn't apply to federal unions. From the position or the perspective of the administration, they've got an adjunct of the federal workforce, that is, federal employee unions speaking on behalf of federal employees that are consistently supporting Democrats. So, from their perspective, it has become a political workforce, at least through the unions at least from their perspective, and at least based on their experience where they felt some employees weren't doing what they were supposed to be doing to help the administration. So that's the purpose of Schedule F. Now, will it be implemented? The administration is moving out fast to identify employees who will be placed into Schedule F. I suspect that the final decision on the constitutionality of it will be decided by the courts. That will take a while. We don't know how long it will take, months, maybe a year or two. Certainly, FedSmith will work to keep everybody advised as to what the latest is on Schedule F and how it will affect you. We wish you the best of luck. We hope that everything works out well for you on this, and thank you for watching our video. We hope you enjoy it. Hope you find it useful.